The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Welcome back, everybody. We're here for our Wednesday night meeting, having had a Tuesday night meeting. And before we go to closed session, is there anybody who would like to address the board? Ms. Armstrong?
Yes, we have one public comment. Karen Jackson.
Okay. Karen, could you just hold that thought for a second? We have our last board members logging in.
Sure.
And there he is. Okay, Karen.
Thank you.
Thank you for waiting. Appreciate it.
Thank you. I'm a teacher in the district as well as a parent of graduates, of students in the district. And I've had the pleasure of working with students in Lodi since 2001, as well as working as a teacher since 98. Prior to that, I worked as a preschool teacher since 1982. And I can tell you that during my nearly 40 years with students, that I can say with no hesitation that this past year has presented me with unique challenges in ensuring that the educational, social, and emotional needs of all of my students are being met. The pandemic has brought to light many areas that we as the school community do things really well, such as when teachers and families and students and staff work together to help to solve challenges brought forth by the emerging global crisis. It has also brought to light areas in which we need to do better, such as providing mental health services, finding immediate solutions for technology challenges, and having respectful and timely communication. And it's this latter area that I wish to address. At last night's board meeting, there were many comments made disparaging teachers. And while we're pretty used to being the scapegoat for a pandemic that is not of our making, I do believe that collaborative discussions between leadership, school staff, and the community would help solve this issue. The incident that weighs heavily on my mind, however, is when a letter from a community member was read aloud by Dr. Washer. A specific teacher was mentioned by name in this letter with a quote attributed to her that she didn't even make. To publicly name someone with a specific intention to berate them and malign their name within the community is egregious. I am alarmed that a community member is not only given the platform to spread falsehoods about a teacher, but that the community member is supported in doing so. I'm hoping that this community member offers a public apology to the teacher involved and that Dr. Washer and the school board does as well. One of the greatest things that a leader can do is to publicly admit their mistakes, because we certainly all make them. And a mistake has certainly been made here. Thank you very much for your time.
Very good. Thank you, Karen. All right. Ms. Armstrong, do we have any other comments?
No further comments.
Very good. Then we will adjourn to closed session then.
Ron, is there supposed to be like a breakout?
There's a second load. You should have.
Oh, go to the
received
second one. Got it.
the closed
Okay.
session, yes.
Thank you.
Do you mind? Okay, that'd be great. Thanks, DJ.
Nobody's there but George.
Yeah, sitting here in the dark.
I think we're live and we're being recorded. And we're good to go. George, are you there?
I'm here.
All right. Okay.
I don't think I've shared a screen. Can I share a screen from my perspective, from where I am? I was looking at the Prezi.
Kim, as good as you are, you can do whatever you like.
Let me just get the permissions real quick.
Oh, no. I do not see a,
I have one question for Kim. Do you have a Ferrari?
wouldn't that be great?
Okay, that's all I wanted to know.
No, I have a Ferrari flag signed by a driver. Does that count?
Two drivers signed by a world champion.
Signed
Kim,
by a
would you
world
like to share
champion,
your
that's
screen
right.
now?
What's that, DJ?
I was just asking Kim if she would like to share her screen now.
I would love to share my screen now, if only I knew how.
I can
I
get you the
haven't done,
permissions right here.
say that again?
Isn't there a share screen button?
Oh, show my screen. Okay. Can you? Are you looking at a Prezi for the Brown Act?
Oh,
You
yeah.
are. Excellent. Well, you all went away, so I can't see you. So when you have something to say, you're just gonna have to jump on in.
Sure.
Thanks for having me tonight, and I want to talk a little bit about, oops, what just happened? It went away.
Kim, I got to call this meeting to order first, so let me go ahead and do that.
Yes.
So welcome everyone back to our March 24th Brown Act training meeting. Before we get too far ahead, let's rise for the Pledge of Allegiance. Dr. Washer, I don't think you've ever led us in the Pledge of Allegiance. Would you mind doing that tonight?
Of course, thank you. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Very nice, Dr. Washer. Thank you very much. All right. Report from closed session. We have nothing to report. But our discussion is tonight on, we have an open mic.
Oh, yep, sorry.
Brown Act training. And we have one of the best here training us tonight, and that's Kim Kingsley Bogard from the firm of Kingsley Bogard. And we're always very happy to hear from her and learn from her also. So Kim, you have a presentation for us?
I do. All right. So I have a Brown Act presentation. It can take as much as 2 hours. What I want to say is I understand that the vast majority of you, I know all of you have been through Brown Act training, and I know some of you have been through it multiple times. So my plan is not to belabor the smaller intro kind of pieces of this presentation that we might do for brand new board members, but kind of hit on the hot topics, questions and concerns that get raised with regularity, and including some issues that have become highlighted as part of COVID and what we're doing in COVID. So get rolling here. Again, when I'm on my presentation screen, I can't see you, so you'll have to just jump right on in if you have a question along the way. And I will run through some of these, as I said, some of these faster than others. Can I make that go away? Okay. So the first thing is talking about a meeting, and while I won't belabor, what a meeting is when it's properly agendized, that sort of thing, what I really want to talk about as a starting point is what is a serial meeting. So one of the issues that happens with serial meetings is that we're required to have everybody come together in a properly agendized meeting under the Brown Act to have a conversation about items that are within your jurisdiction. But sometimes conversations or communications occur outside of a meeting that create, outside of an agendized meeting, that create something called a serial meeting. And it's in violation of the Brown Act, and they typically happen through something called the chain and the spokes. I want to talk about what it means to be a serial meeting. First of all, prior to 2009, there was a case law that talked about the fact that it didn't constitute a meeting for a majority of the board to have contact with one another, to have discussions with one another on an item within jurisdiction, unless you ended up in a situation where you reached what they called a collective concurrence, meaning you walked away from that level of interaction with an idea about what the outcome would be. And so that's what the rules were prior to 2009. After 2009, there was an amendment to the government code, which is where we find the Brown Act, and they eliminated the collective concurrence language. And so what you have now, it's violation when outside of a properly noticed public meeting, a majority of the members of the body, oops, where'd it go? Sorry. Use a series of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business within the subject matter. So discussion is enough, just discussion. We don't have to have an outcome. You don't have to know exactly where people are going to be on the item, just discussion. And this raises questions about the kinds of communications that we have. So let's look first at the chain. The chain is the most common piece that happens, especially with technologies these days, between having texts or phone calls or emails. There are lots of ways for this to happen, sometimes unintentionally. And that the classic way to create a serial meeting is for member A to talk about something within the jurisdiction of the board with member B, who then takes that discussion and moves on down to member C. And that ends up creating what we call a serial meeting. The other thing that can happen is when you have one board member who ends up talking to two other board members, member B and member C may be oblivious to the fact that member A has talked to them both, but it creates a serial meeting nonetheless. And this one is kind of interesting. This one, I think, raises some questions about communications with even members of the public. So if you think about intermediaries, classically, intermediaries have been, I think of this more in the terms of like lobbyists or, people who are sending their employees or their representatives out to have a conversation. So you have a representative who understands my point of view. I send them out and they talk to your representative who understands your point of view. And we're trying to circumvent the rules by having a conversation through, one layer removed from a board member. And that also creates a serial meeting. One of the things, actually, I'm going to leave it on intermediaries, because one of the questions I think arises what happens when members of the public call and want to have a conversation with board members about their point of view on a topic. And that's not uncommon, and it's not inappropriate in any way. But then what happens along the way if that particular person moves on to talk to other board members? They're not your intermediary, so you aren't sending them out on a fact-finding mission for you, right? I think that the concern that I would have here is drawing a line politely with folks when they wish to share with you information about what another board member said to them. So this is one of those areas where I think you politely decline to hear about other board members who are more than happy to have your conversation about your viewpoint, but simply can't get into understanding or knowing what other board members are doing. Okay. So requirements I don't want to spend a huge amount of time on. I'll run through these pretty quickly. Stop me if there's an area that you want to talk about in greater detail along the way. So
Kim, just real quick, apologize for interrupting you, but your diagrams were okay because those didn't involve a quorum, right? So as long as
these diagrams are made for a 5-person board, my apologies. It requires one more. You're a 7-person board, which is not the norm. But yes, you're correct.
Okay, so as long as
it's 4 for you, not 3.
Okay, very good. Thanks.
Sorry about that. So we know that for a regular meeting, we have 72 hours notice, and we need to post to the local agency website 72 hours in advance. That's something that came along recently in 2019. And you have to put your time, place, and a brief description of those items to be discussed in an open and closed session. Brief items based on case law is generally about no more than 20 words, right? You can get it done with no more than 20 words. Special meetings crop up when you have, when you can give 24 hours notice. Again, it's 24 hours. I think this must be in the way. 24 hours notice in advance of the meeting. It has to be published as well. And again, you do have to have the time in place and a brief description of those items. Non-agendized items generally are not a topic for discussion. Sometimes folks are going to raise concerns or questions to you in public comment, which I want to talk about in just a minute. And in situations where you want to have a very brief discussion or to seek clarity, even though it's not on your agenda, you can take a few words to get some clarity and to provide some direction to administration. But the general rule is you're not having any discussion on items that aren't properly agendized. There are some exceptions to the rule. I won't belabor those tonight, but those are always available to see in the Brown Act book, including emergency situations, continued agenda items, and as I just said, limited discussion and comment. Location is important. Your meetings have to be within your boundaries, and there are very few exceptions to that rule. You can have teleconferencing in, but the majority of you have to be within your boundaries. Something that some people don't understand is when you engage, when you have a teleconference location, it has to be open to the public. Most of the time people are in a hotel room when that happens. So the rules are a little bit, to some extent, silly, but you do have to make your, the space in which you're attending the meeting has to be open to the public. And you have to put an agenda on your door. So you basically post the agenda on your hotel door and kick your door open. Let's talk about public participation, because this one I think is coming up more and more. And I think that folks are struggling with this more in light of the pandemic. I think that public participation was maybe less of an issue, or perhaps it's just highlighted. The issues are highlighted because of the fact that we're doing much of our meeting electronically, or permitting folks to engage with us electronically. So folks have the right to receive and inspect materials, and those are all listed there. But here's the one that I think is an important topic for discussion, and that is public participation. Why is that not going back? There we go. Public participation and your ability as a board to adopt time, place, and manner regulations. If you go back and look at your board policy, you will have a policy that indicates when people are permitted to speak during the meeting and how much time they have to speak. And I think that this becomes a really important governance piece for you, because if one is allowed to speak for long periods of time without restraint, you end up staying there late into the night, finishing your good work, right? So that a lot of times folks they come for public comment that's on the front end. They take up huge amounts of time with lengthy statements, and then you don't get underway. The one thing we have to make sure is that it's viewpoint neutral. People are permitted to speak on whatever their viewpoint is, as long as it's not discriminatory, right? Or in some other way, impermissible speech. But we have impermissible restrictions. There we go. They are permitted to make recordings, and the only time that you can stop them from making reasonable recordings, and I've had people ask about this because sometimes people come with cameras and they want to be right up in your space, but they're permitted to do that for so long as they're not making too much noise or creating obstruction of your view, etc. We can't put preconditions of attendance on folks, and we can't ask them to register their names, complete questionnaires. Those are things that come through. But you are permitted to have an orderly meeting. And this kind of goes back to the public comment. I think that some folks, some places say, okay, we're gonna have 3 minutes is a really common norm. You have 3 minutes to speak, and you may speak for only those 3 minutes. You might carve out an exception for your bargaining unit groups. You might provide them, while there's absolutely no requirement to do so, some places do carve out a slightly more time than what's provided to the average public in their ability to address you. But if folks stand up, I think that sometimes people stand up and they're very heated on a topic. Generally, remember, we can't have a viewpoint restriction. So if I stand up as a member of the public, I have the right to talk about my displeasure with the way something is going with the school district, right? That's within your jurisdiction. But I don't have the right to be disruptive and to prevent the meeting from moving on. Most people don't have issues with this, but you do have the right to keep an orderly meeting. And if you can't restore order within the room, if things really get out of control, you have the ability to stop the meeting and clear the room so that you can continue in your session to get your work done. I haven't had people have to do that very many times. The other piece I want to talk about briefly before
on that last topic, kind of in that session, what if somebody wants to personally attack a board member or a school employee during that public comment?
Yeah, you know, I think it depends on the definition of personally attack, right? So if we're talking about, I want to stand up, for instance, and I want to say, Mr. Freitas, I think you're doing a terrible job. I think you're voting wrong on all the issues. And I just think, you know, I think it's terrible. I have the right to say that as a member of the public because I'm speaking on matters within jurisdiction. Now, if I stand up and I want to have a conversation about things that are like personally defamatory, or if I'm being belligerent at the mic, things, and when I say personally defamatory, I mean things that don't have anything to do with your job, right? Things that aren't within the jurisdiction of the board. But generally speaking, there's a wide, as public officials that were voted into this job, they have the right to speak about whether they're happy or unhappy with the job you're doing.
And what if they came after one of our employees? They said, hey, you know, this school secretary that we have, she's the worst school secretary in the world. Her car is always dirty. And
yeah,
and I can't believe the way she dresses. And, you know, what if it was something?
Sure. I think that it is perfectly okay for the board to stop a public comment in that regard. One thing I think is important for members of the public to understand is while they have the ability to speak to you about matters that are in your jurisdiction, that doesn't give them a bulletproof defense if they're going to stand up and say things that are defamatory about employees. Employees are not public figures. They didn't agree to be subject to the same level of scrutiny that you are. And when someone starts to complain about an employee and they're going down that road, I recommend that the public comment be interrupted and allow them to understand that there's a process for complaints against employees. You have a process through your governing board policies for how to handle those. And I would recommend that they be stopped and pointed in that direction.
Real quick, Kim, this is Sue McFarland. I'm questioning, can they say that about our cabinet or our superintendent, for instance? Are they considered, they're not an elected official and they're considered an employee. Can they do the same thing to our superintendent?
Sliding scale, right? You're at the top of the chain. So, you know, their opinions will be, I think it's a sliding scale for when we can cut them off. And you're probably not looking to cut off above, probably principal and above are areas where I think people have the right to speak on their concerns publicly. Again, I mean, I think it depends on what the charges and concerns are, right? If the concern is, I think that Principal Jones does a lousy job of, you know, traffic control, well, that's something that's going to be open to the public. But I think the more personal you get, or the less policy based you get, the more that should be an employee complaint. But certainly employees that are not in administration are the ones that will receive the most protection.
Thank you.
Mm-hmm. So there, you can hold an emergency meeting, but that's fairly rare. I don't know how many you've held in your time, but those typically something that we're looking at when those issues arise. So Closed session. Let's talk a little bit about closed session because I think most of the rules are simple when it's an open session item. We understand how to agendize that and what the rules are. But closed session can be a little bit trickier, and there are only certain provisions that you can speak about in closed session. So one is conference with legal counsel. And this is one of those areas where the basis for closed session is the attorney-client privilege. So in this situation, legal counsel comes in and we're protecting the conversation because to have it in open session would disadvantage the district in litigation or defense against litigation. So that is one of the common closed session pieces. Liability claims are another one that come into closed session. Threat to security, public services, or facilities. I have to say, I haven't personally seen that one come up. It's probably very rarely used. Conference with your real property negotiator. I'm sure that comes up with some frequency whenever you're building schools, acquiring property. Again, it's that concept that sharing that information with the public is a disadvantage for you. And of course, student expulsions are something that come into closed session, and those are student privacy right. The personnel exception, this is one that I think is kind of interesting. Sometimes it's it's too broadly construed for what is contained by law in the personnel exception. The personnel exception is specifically limited to considering appointment, employment, evaluation, or performance, discipline, or dismissal of an employee. So it's not a catch-all beyond those specific pieces. And when specific complaints or charges are brought against an employee by another person or employee, those are something that would also come into closed session. I think that one of the pieces that's really important to remember is that when charges or complaints are going to be heard by the board, there is a government code section that requires that you give employees 24 hours notice before you hear those charges or complaints. And it's a really important piece. It doesn't apply to teachers. Teachers are unique in that they have a panel that hears their disciplinary case through the CTC, the Commission on Teacher Credentialing. Classified is different, and classified is anyone, of course, who does not have a teaching credential. For them, the board is the trier of fact to the end result. And so for classified in particular and for administrative employees, we would be looking to give 24 hours notice to make sure that the disciplinary process is intact. And failing to give that notice can or will null and void any conversation or charges that were talked about in closed session. Bargaining and negotiations is also a very interesting place, and I think it's a little known fact. Some boards are well versed in it, but most are not. Bargaining is something that you can take into closed for salaries, fringe benefits, and other mandatory subjects. So that's any term or condition of employment. But what folks don't understand is that for school districts in particular, this is also an exception to the Brown Act. And boards can come together and speak on issues on the very narrow topic of negotiations so that you can give feedback to your negotiators. If you think about it, it really makes a lot of sense. A great example where this comes into play is you are in mediation. You send your administration and legal counsel in for mediation or other kind of meeting, and we reach a point where at 7 o'clock at night and we say we think we have a deal, but we need to talk with the board. We need to get some direction from the board. And to ensure that we get this timely feedback, we are permitted to call each board member individually and poll you, ask you for what your outcome will be, and or we have the ability to pull you together for a board meeting. And of course, in today's environment, that is easier than ever for us to all sort of jump on to a Zoom or whatever electronic platform. But it's, I think, something that's not understood necessarily by the public. And the reason really is to ensure that we can have timely negotiations and feedback for your bargaining units. So on AB 1344, there are some prohibitions. You cannot consider, discuss, or act or approve the salary or salary schedule for a local agency executive. This has gotten broader and broader over the years. You may have been, some of you I know were on the board before the initial Bellflower case came down that said you can't talk about salary, right? Salary is something that we couldn't talk about in closed session about for superintendents or anyone who had superintendent in their name. And this has slowly morphed into a broader category of local agency executives. And the reason for the prohibition, I think, is pretty simple, that the salary that is paid to any agency executive really is part of your financial outlook, and the folks in the public have the right to weigh in on that topic. So you can talk about terms and conditions of any contract for an executive, but when it comes time to talk about the actual payment, the amount to be paid, that will occur out in open session. And special meetings are okay to talk about, to discuss in the context of budget discussions. On closed session meetings, I don't see too many issues with this these days, but it's important to understand that closed session meetings are typically, they're closed because there's a privilege that exists there. We're either concerned about violating, for instance, a student's right to privacy, but more often than not, we're creating, there's typically an attorney-client privilege or other privilege to withhold that information from the public at large because it disadvantages your bargaining power or your buying power, et cetera. So it's really important that the folks who come into your closed session are essential folks who play a role in what's happening in closed session. And by that, I mean that if we went into closed session for to negotiate real property, but we invited someone into that closed session who didn't play an essential role in that property negotiation, we would basically lose our status as closed session. We can put ourselves in a position where information that is given in closed session is subject to public disclosure because we didn't follow the specific closed session rules. Voting, this one I think is really interesting, and voting is one that I think that folks don't always think about or should be thinking about as far as what happens when you abstain or recuse yourself. I know that issues come up along the way where folks need to abstain or recuse. And this is an area where we get a lot of questions. So generally, voting for you is done by majority vote. And so you are majority for you is a vote of 4. And sometimes folks need to abstain or recuse themselves, and there are a variety of reasons why. So if you have a financial interest in a contract, meaning that maybe you had shares in a contract, for instance, shares in a company for a contract that was coming forward. You might have a remote financial interest in a contract. You might have some conflict of interest. One of the questions that frequently comes up is, I'm a board member and for instance, my child works in the school district as a teacher. can I vote on that collectively bargained agreement? And the answer to that is yes, because that financial interest is not your own. That's your child's financial interest. You can also vote. The other question that comes up with some frequency is spouses. Oftentimes when a board member joins the ranks, if their spouse has been employed, again, I'll use teaching as an example, if they've been a teacher for more than a year in advance of when the board came on, again, you can vote on those contracts. And the reason for that is that the contract affects a large group of people. And so you are voting on something that has a widespread effect on folks more than just your spouse. And you can see why they put the 1 year piece into place. What they're trying to avoid is a situation where the board member sits and then makes a decision, for instance, to hire the spouse or to put the spouse into school district employment. The other piece that comes up with regard to spouses is the issue of promotion. And unfortunately, and I don't know if it applies for anyone here, but if you have come onto the board and your spouse had been teaching for 10 years, they will not be in a position to promote up financially while you are sitting on the board. And that's something that comes up as well. So we tend to get quite a few questions on the issue of conflict of interest in particular. But on abstentions and recusals, I think that one of the pieces that's important to understand is how your vote counts. And generally speaking, when you have, and I wonder if it's on this next one, generally speaking, when you have to abstain because you are required to do so by law, your vote doesn't count. When it makes a difference is abstention for personal choice. Sometimes folks need to not vote on an issue for personal reasons. They simply find it just not palatable, something that they simply cannot put their vote on the table. Now, some would argue that that is contrary to the requirement of board members to act and to govern the school district, but it does happen from time to time. People say, this doesn't feel good to me, so I can't vote on this issue. When you abstain for personal choice, your vote is counted, but it may count in a way that you don't expect. So if you have, if you abstain for personal reasons, your vote will get counted with the majority. And I think sometimes people don't understand that. I've had board members express confusion over that, especially if you are first up, right, to make a vote and you abstain, and then thereafter the votes come in and you get added to the majority. Sometimes the outcome is really not what you expected. So that's something to be aware of. Report of action taken. Anytime you're having a collective decision, commitment, promise, or an actual vote, you're going to report out the action taken in closed session. A lot of times your report out is giving direction to council, giving direction to administration on items that you wouldn't give any more detail on because it's negotiation related or litigation related. And I think this is what I just talked about on the vote reporting, vote or abstention on any board action for each member present for the action. And it can be, you have to report out whether or not. So if I abstain on an issue, that has to go out. My abstention has to be reported out. Other questions along the way so far, or things that are important to the board as far as things that are maybe cropping up as part of doing meetings online. Other questions or concerns? Okay, hearing none.
No, Kim, you're doing great. Thanks. Keep going.
Just I'm just barreling through, and I think I'm hitting some of the issues that are definitely coming up as part of COVID in our virtual times. So enforcement of the Brown Act is something that comes up from time to time, and I'll run through those. On the criminal side of the house, I haven't seen a lot of criminal enforcement, thank goodness, with the folks that I interact with. But here, when you have an action, and it's a pretty high threshold, right? You're taking an action, you know darn well it violates the Brown Act, and you intend to deprive the public of information. That's when criminal or misdemeanor issues crop up, and it could be as much as $1,000 fine and up to 6 months in jail. Civil actions are something that would be more common. You would see a writ or an injunction coming in, or some kind of declaratory relief asking for the board to go back and cure what they've done, and looking to prevent it in the future. Before they can bring a civil suit, though, and we have seen some of these in recent history, they do have to make a demand. And so on a demand, they have to give you an opportunity to correct within 30 days. And the vast majority of the time, it's simple enough to double back and correct, cure and correct the issue that's been raised. And that has to get done before they file for a civil action. So you're not going to find yourself in a situation where somebody's filed for suit, or you shouldn't, before they give you a letter and tell you what they think the problem is and how they think you should fix it. So you might get, on a disclosure for confidential information, you might get injunctive relief to prevent disclosure. You might have the grand jury looking into the issue. It depends on how excited your jury is. And you might end up with a disciplinary action against an employee who willfully disclosed information. I think it's important for folks who are in administration to remember that this is applicable to them. This is not just a board member issue, right? Board members, you are elected officials. You are not subject to disciplinary action. You are obviously held to the standards of the law, different than what we might do with an employee that we know is willfully going out and disclosing information that they're getting within the closed session. Non-violations, these are going to be folks who are going to be seen not to have violated disclosure of confidential information would be, well, first of all, it's not confidential. Maybe I'm a whistleblower and I'm concerned that there are violation of laws. Those sorts of things are not violations. And the effect of the violation is that the actions you take are legally null and void if they violate the Brown Act. So I'll give you an example. One of the issues that came in was we got a complaint that a board took action on an item without allowing public comment before the action was taken. And in a situation like that, if you feel like if you're anywhere near the edge of concern, it's easy, on almost every case, it's easy within the 30 days to double back and simply take the action anew. It gets more complicated where you have intense contracts, but I would say generally we can cure and correct almost any violation when they are procedural issues that are being called out by members of the public or perhaps bargaining units. So one of the pieces that can happen is you can end up having costs for attorney fees. So you may have to pay out if someone gives you a cure and correct. You choose not to go down that path or don't cure to their satisfaction, then they would file a civil suit. And if they prevail, you'll be on the hook for the fees for attorneys. Generally, though, there's no personal liability as a public officer or employee. That would only occur in situations where you had a criminal, right? Though I talked earlier on about the fact that there could be criminal liability if you went forward with the intent to deprive the public. So one of the questions that comes up from folks, they often ask, what's sort of the touchstone for the Brown Act and for determining whether a conversation, I want to go back to conversations that are maybe serial in nature. And folks say, well, I'm concerned, or I'm not sure how to determine whether this is going to be a serial conversation. And for me, I think one of the touchstones is asking, are we depriving the public of the ability to hear, right? Hear our deliberation, hear our thought process for the why of what we're doing. And whenever you feel like the conversation that you're having with a majority of the board or is getting passed to you from other folks, the more that feels like we are in a position where the public's going to miss out on really critical discussion. That's when, for me, that's the red flag. That's when I stop and really look and analyze what's happening with regard to those conversations. So I don't know if there are other areas that you want to talk about. I know I went through that fairly quickly. As I said, I know you've had training in the past, but really wanted to make sure that we were hitting on things like the closed session, the public comment, which is a whole new ball of wax now that we're in a digital environment. And
Hey, Cam, George Neely.
Hey.
Real quick, what about sharing information that you get from somebody else? As an example, a constituent sends an email with an attachment on it of a news article or something like that. Is the Brown Act affected if you just take that and forward that email or share that link and there's no discussion that takes place? Or something, every board member here does a lot of research.
Sure.
Sometimes we find something and how about sharing that, again, without comment, without discussion?
I think if you're sharing something that's just, for your reading pleasure kind of thing, and there's and there's no discussion about it, I think that's a situation where you are not discussing. Now, if I were taking an aggressive approach, what I would say is if it was an article that was heavily opinionated on an item that was within your jurisdiction, now I'm thinking this is an area where someone would argue that you are educating someone on your viewpoint, right? I'm discussing with you through an article. I know that that's a looser interpretation, but if it's a matter within your jurisdiction and we're sharing an op-ed, for instance, that speaks to your point of view, that could be more problematic. Different from perhaps a study that was done on education of kiddos, where it's just data.
Got it. Thank you.
Real quick, Kim, it's Sue McFarland. Can you talk a little bit about text between board members, whether it's a group text or a private text? Are you going to the meeting or you're not going, whatever the context of it is, other than obviously discussing something in closed session or an action item. Can you talk a little bit about that?
Sure, I think texting can be a major issue. And one of the pieces, uh, I want to talk about one issue that's come up in other locations, and that is texting when you're on the dais with one another on the dais. I'm sure that you've heard horror stories in some locations where that happens. And certainly, if you are having an open session dialogue and folks are texting on the dais, and I know that wasn't your question, but texting on the dais, that actually would be depriving the public, right, of your debate, of your thought process for the open item. So that's a problem that we're seeing actually with some great frequency. Your question kind of goes back to, I think the question is, are you talking about something within jurisdiction of the board, or are you just talking about dates, right? I think it's different if you're saying, hey, can you make the date of the 12th work? Can you make a, you know, those are rote conversations that I don't have any issue with. But if you're talking about any issue that's going to come before you for a decision, that's where we've got a problem.
No, that makes sense. I just, that comes up a lot with people asking questions. And so I was just seeking clarification.
Yeah, and the safe place, right? When they made the changes to the government code that said that you don't have to have a collective concurrence anymore, you just have to have a discussion in order to violate the Brown Act, they were clear that you can utilize the superintendent or administration as a place to send those questions back. So the superintendent, there was a lot of concern that the way they were describing a serial meeting and the fact that you could use an intermediary, there was fear that superintendents would be viewed as the intermediary, and there would be just an onslaught of Brown Act violations. But we know that the superintendent is a safe place to send questions, look for follow-up, and not have a serial meeting. So when questions occur, the strong recommendation is for those questions to go back to the superintendent rather to other board members.
So Kim, maybe following up on George's, say I find an interesting article on COVID, how a district's handling COVID. Can I share that link with my other board members?
I think, can you share that with other board members? I'm not seeing that it's necessarily a discussion. I think that if it's just an FYI of information for people to consider, research to read before you show up, I think that's okay. If it's, I mean, it's public information in the newspaper. This is what other districts are doing. Food for thought, right?
Okay, and then to follow up on Sue's, there's been some changes. Can we go over once again with social media? I guess Ron Freitas is board member. If I like a comment, that can get me in Brown Act trouble?
Yes. So one of, I think there's a broad definition of what it means to discuss. And I think that this kind of goes back to, it's a little bit of the case-by-case basis on what kind of article you're sending to other board members on whether or not you're sharing your opinion, right? Whether you're sharing how you might vote on a topic. And I think that, people didn't think much about going in and liking a board member's post on Facebook about, and then actually have had this issue in some other districts where someone goes on and they say, I support the fact that we're going to do X, Y, and Z with our educational program. You get other board members on there getting the thumbs up, and that is absolutely the sharing of and discussing of a topic in your jurisdiction. Very
good. Thanks, Kim.
Yeah, I think what's tough about this is just that some of these are going to be fact specific. Would a reasonable person look at that and say, this ultimately amounts to a discussion? It's a low threshold. I think people need to keep in mind that it's a low threshold. When they moved away from collective concurrence to just discussion, that doesn't take a lot.
Very good. Other questions for Kim from the board? All right. Kim, I know that was a lot of information. We also have your written materials, so I think
Yes.
I think that's going to do it for tonight.
Absolutely. Well, thank you for having me. And if there are follow-up questions, obviously I'm here to make any clarifications for you.
Very much appreciated as always. Thank you.
Thank you.
Thanks, Kim.
Other comments from the board?
Ron, this is just more of a, I don't know, an attaboy thing, but I was pretty familiar with most everything, but the Facebook and social media thing hit home with me. I never even considered that being any kind of a chain type of a communication, but I could see where it would be. That was good information.
All right. Thank you, Gary. All right, if there's no more comments from the board, we'll go to comments from the public. Ms. Armstrong, you are joining us tonight as always. We have our IT tech extraordinaire DJ with us, and thank you for being with us tonight, our executive assistant to the board.
Yes, we have one public comment this evening. Michelle Orgon.
All right.
You did.
Hi, Michelle.
Good evening, President Freitas, members of the board. I am guessing that this would go back to Kim or Dr. Washer for clarification, but there have been a couple of meetings that the board has held as they are discussions, not meetings, and so they did not need to be posted, we were told, or made public. And so I guess from what I just heard, those meetings that have been held since last May, where the agendas weren't posted and were discussions should have been made public. Would that be your understanding?
My understanding, Michelle, would be that if it was in one of the exempted categories, they would not need to be public. So all discussions can qualify for Brown Act, but I don't know if you were sharing the same screen that we are. Certain things would not have to be disclosed.
Right. Well, we had no knowledge of what was being discussed. We were just told that they were board discussions and they were held to be private. I think the last one we have down was September 30th. So our question would be, would those qualify as what Ms. Bogard described as any discussion where the group meets would need to be made public and time to come back and be informed, the public be informed of what would be discussed at those discussions?
I don't know.
Kim, are you still on the line?
Yeah, I am still here. I don't know. I can't see people for some reason, but yeah, I can hear you. So here's what I would say. So a couple of pieces. One, typically questions raised during public comment would simply be given to administration to follow up. That would first be my recommendation, as opposed to doing sort of a Q&A during the public comment piece. as for whether any particular meeting qualified, certainly, if the board were to ask, I could look at that with Dr. Washer.
Thank you, Kim. That's all I have for tonight.
Okay, thank you, Michelle. All right, any other comments from the board based upon public comment? All right, with that, we are adjourned. Have a nice evening, everyone. Be safe.
Thanks, everybody.
Thank you.